Marriage is one of the biggest commitments in your life, and one where the government can change the main rules after you sign. Not the small print, the rules that matter most. Who is allowed to leave, what reason they need, what it costs the one who stays. You don't write those rules, neither does she. The state sets those rules, and the state can change them later without asking the people already living under them to sign again. Compare that to anything else you sign. A mortgage, a car lease, a business partnership, the terms on the phone in your pocket. Sign one of those, and the deal you signed is the deal you get until it ends. If you're the man being told it's time to settle down, here's what that means for you. You're looking at a woman and a life, and that's a fair thing to be thinking about. But the rules that decide who keeps the house, who pays who every month, and how many nights a week you see your own kids, some of those rules haven't been written yet. Some will get written in 20 years by people who are in high school right now. You'll be bound by all of them. Nobody will hand you a new page to sign, and there's no way to lock in the version you agreed to. Start with 1970, because that's the year everything you're being told to sign changed shape. In September of 1969, the governor of California, Ronald Reagan, signed a new family law. It kicked in on the first day of 1970. California became the first state where a marriage could be ended without either person having to prove fault. Before that, you had to go to court and prove the other person did something wrong. Cheating, cruelty, walking out. In some states, drinking. You needed real evidence, and the other person could show up, argue, and win. That mattered for one practical reason. Two people had to be involved for it to end. One person wanting out wasn't enough, so a man signing in 1955 knew exactly what it would take to end his marriage, and knew he had a say in it. The door had two locks. After January 1970, one lock. One person can end it, any reason or none. The law used the phrase irreconcilable differences. In normal English, that means one of the two says it's over, and the old way was bad. People faked affairs in hotel rooms with photographers, so a judge would have a picture to look at. Couples moved to Nevada for 6 weeks because Nevada would grant what their home state wouldn't. Lawyers rehearsed clients on what to say on the stand. That system needed to go, and I'd say the same thing if I'd lived through it. Two things happened in 1970, though, and people only talk about one. The rule changed, which was overdue, and the new rule was applied to marriages that were already signed. Think of that like your bank changing your loan terms and applying it to the loan you signed 10 years ago. Lawyers call that retroactive. Picture a man who got married in 1952. When he signed, his wife could not end the marriage on her own. In 1971, she could. Nobody called him. He didn't sign anything new. There was no option where he kept the old terms. His deal changed, and he found out about it the way you find out about anything, after it already happened. That happened to millions of marriages at once. The people in them never got a vote on it. The rest of the country moved fast. Iowa did it the same year. Within 5 years, most states had some version. The last ones held out into the 80s. New York didn't get there until 2010. 40 years of fighting over something that supposedly wasn't a big deal. And Reagan himself was divorced when he signed it. His son has said Reagan later called that signature the biggest regret of his political career. Whatever you make of that, it tells you the change was larger than it looked at the time. Here's why the ending rules matter more than anything else in an agreement. Everything else gets priced off them. What you put in, what you get, how long it runs. All of that depends on what happens when it falls apart. Look at a commercial lease sometime. 50 pages. Roughly 40 of them are about one thing. What happens if this goes bad and somebody wants out? The other 10 pages tell you the rent. take the 40 pages away and the 10 mean almost nothing because you have no idea what you're actually exposed to. So when the ending rules of marriage changed in 1970, everything above them changed too. What a man was putting in was worth something different. What he was risking was different. The thing he signed in 1952 turned into a different arrangement, with the same word on the front and the same signature at the bottom. Try that with a loan and see what happens. Say it's 1975 and you sign a 30-year mortgage at 7%, fixed. Fixed is the whole reason you signed instead of renting a few more years. You wanted to know the number. Now say in 1989 the state decides fixed rates are unfair to the banks. It passes a law turning every fixed mortgage in the state into a floating one. Nobody calls you. You can't opt out. Your payment triples and you learn about it from an envelope in April. That law would be dead in a month. Homeowners and banks would be on the same side for once. Every lawyer in the state would want the case. It wouldn't even be close. Everybody sees the problem with the mortgage instantly. The marriage version actually happened and barely anyone noticed. And the reason the mortgage guy wins is one sentence he gets to say in front of a judge. You can't change a deal I already signed. That sentence can carry a lot of weight for him. A husband does not have that same contract argument available in the same way. That's the part worth understanding. Now a smart guy across the table will push back here, and he's got a decent point. He'll say every contract sits inside a legal system, and legal systems change all the time. Job protections changed. Rent laws changed. Interest rate caps changed. People who bought land in the 50s got told decades later they owed money to clean up pollution nobody knew was under it. Nobody signs anything in a world that stands still. That's true, and it isn't the claim. Nobody's saying laws never touch contracts. They touch them constantly. The claim is narrower. In a normal private deal, the two of you write the terms yourselves, and the law works around the outside. In marriage, the terms were already written before you walked in. The state holds them, and the state keeps the power to change them. There's a line in the Constitution about this, from 1789, and it's short enough to say in plain words. A state can't pass a law that breaks a deal people already made. The men who wrote that had just watched state governments cancel debts and rewrite agreements after the fact. They figured a country where that was normal would fall apart. So they put signed agreements mostly off limits, which means the normal rule runs the other way from what you'd guess. Contracts are the one kind of deal governments are specifically told to leave alone once the ink is dry. That protection has holes, and courts have picked at it for 200 years, and I want to be exact here because the exact version is worse for you than the loose version. Governments do touch existing contracts around the edges. They cap what a lender can charge from today forward. They cancel clauses that were never legal anyway. That's normal. What they mostly can't do is take the thing the two of you actually negotiated and swap it out. And here's the piece with no equal anywhere else in your life. A bank writes the loan. A landlord writes the lease. In marriage, the state wrote the terms before either of you showed up, and what you two supply is mainly the agreement to walk into a system that was already built. When a government does reach into a signed deal, the person who gets hurt can go to court and argue the law can't touch what was already agreed. Sometimes he loses, plenty of times he wins. The point is, he gets to make the argument. A landlord can make it, a bank can make it, a guy who bought a franchise in 1998 can make it, a guy who signed to supply parts to a factory can make it. A husband can't. That was settled in 1888, long before anyone signing today was born. There was a couple out west, back when Oregon was still a territory. The legislature ended their marriage by passing a law with their names written into it. No hearing, no reason given. Just a law saying these two are no longer married. Years later, the wife's side took it to the Supreme Court. Their argument was simple. Marriage is a contract, and the government can't destroy a contract like that. The court said no. Marriage is more than a contract, it said. Marriage is a status. A status is something the government creates, like a driver's license or citizenship. You have one, it means something real, but you didn't write the rules for it, and you can't freeze them. The rules for a license can change while you're holding it. That's what the court decided marriage is, which is why the protection that covers ordinary agreements doesn't reach it, and why a legislature can change the terms of a marriage that already exists. Those terms were never yours to hold. And that's the honest version. Not that the state can do absolutely anything, but that it has far more room to move here than with a deal you and another person wrote yourselves. Look at the two dates together, 1888 and 1970. The permission existed for 82 years before California used it. California went first. 49 states followed. So when someone tells you to settle down, ask yourself whether the conversation ever included the year 1970, or the fact that the highest court in the country was asked straight out whether marriage is the kind of contract that protects you, and said it isn't. And there's usually one answer left at this point, and it comes fast. Get a prenup. That's a real answer, and it deserves a real reply. Prenups work. They're enforceable in every state. Good lawyers write them, and a solid one has saved a lot of men a lot of money. Anyone telling you they're worthless is selling you something. But here's what a prenup actually is. It's a piece of paper a judge reads. That's it. It doesn't do anything by itself. The day you sign it, it binds nobody. It has no power until a judge decides how much power to give it. So what you've built is a document asking the same government that rewrote the rules of marriage to please respect your private version of those rules. And a judge has a long list of reasons to set one aside. Didn't list everything you owned? Out. She signed without her own lawyer? Out. She signed 3 days before the wedding when the flowers were already paid for. A judge can say she wasn't really free to think about it. And out. He can also throw it out for being so lopsided that enforcing it would be wrong. In a lot of states, he measures that on the day it gets used, not the day you signed. That could be 22 years later, in a situation neither of you could have imagined at the table. California, the state that started all this, now makes you wait 7 days between handing someone a prenup and having them sign it. And she needs her own lawyer before she can give up alimony. Those are reasonable rules. They also didn't exist when older prenups were written, which means those men wrote paperwork under one standard and got judged under another. That's the same thing happening again in a smaller room. The rules your paper gets measured against get set after your paper exists. And there's a whole part of your life the paper can't reach. Custody and child support get decided by a judge asking one question out loud. What's best for the child? No agreement between two adults overrides that. You can sign away a claim to a brokerage account and it'll probably hold. You cannot sign an arrangement about your own kids and expect it to survive. So the prenup protects the part of your life you'd survive losing and says nothing about the part you wouldn't. Somebody will say the 1970 change was good, that it let people out of marriages that were wrecking them, that men who complain about it want a world where nobody can leave. That's fair, and a lot of it is right. People were trapped, and now they aren't, and that's worth something. But a rule can be an improvement and still have been dropped on people who signed under a different one. Both of those things are true at the same time, and the second one is the half that matters if you're deciding today. And the terms covers more than most men picture, what counts as shared property and what stays yours. Whether the state splits it down the middle or lets a judge divide it by what he thinks is fair. How long you pay support, how they calculate it, and whether it can run for life, whether a court can order you to keep paying for a lifestyle you no longer share. What happens to your pension? What a judge decides your business is worth. Whether the years she spent home with the kids count as her contribution or as a choice she made. Every one of those is set by state law and by what judges do with that law. Both of those move over time. Move the formula, and the deal moves with it, and nobody sends you a letter. And there's no villain in this. Legislators change laws because they think the new law is better. Judges get discretion because a rule book can't see the family standing in front of it. Most of these people are doing their jobs the way they understand them. The result on your end is the same either way. What you owe gets decided by people who weren't in the room when you agreed to anything, and who'll still be deciding it in 2045. One thing I want to be flat about. I'm not predicting your marriage ends in a courtroom. Most don't. Plenty of people divorce and handle it like adults. Plenty of men stay married 40 years and would tell you it was the best decision of their life, and they'd mean it. All of that is real, and none of it changes what's on this page. The problem isn't the odds of a bad outcome. It's that you can't price the thing at all. Pricing it just means knowing what it could cost you. You can get a great outcome and still have signed something you had no way to evaluate going in. That's what an insurance company does when it refuses to cover something. They don't know the odds, so they won't take the bet. Nobody calls them cowards. Nobody says they're afraid of houses because they won't write a policy on a place where the rules keep changing. So use the rule you already use everywhere else. You read the interest rate before you sign. You ask what it costs to get out early. You've walked out of a dealership over a number on a page, and nobody said you were scared of cars. You do it because a deal you can't evaluate is a deal you turn down. That's just how a grown man handles paper. And here's a question worth sitting with. How many of the men telling you to commit could name one single term of the contract they're recommending? Here's the specific thing to do, and it takes about an hour. Look up 2 documents. What your state's divorce law said in 1965 and what it says today. Put them side by side. You'll find terms that got replaced. You'll find that nobody living under the old ones was asked about the new ones. Then find the date of the most recent change your state made. That date tells you how recently the rules around a marriage like yours got rewritten, and there's no reason to think that was the last one. There's no version of this you can buy where the rules freeze on your wedding day. It doesn't exist. You can't draft it, you can't pay for it, and no lawyer in the country can get it for you. So a man who declines to sign is doing what he does with any document that shows up half-written by someone who can keep editing it. And everything people actually mean by commitment is still available to him. He can build a life with one woman, share a house, raise kids, stay 40 years and never look at anyone else, be exactly as loyal as any married man on his street. All of that is his to give, and he can give every bit of it. The one piece he holds back is the signature, so here's where it lands. The no-fault rules started in California in 1970 and have been changing ever since. They were changed by legislatures that the people inside those marriages never voted on for that specific decision, using legal authority the courts had recognized decades earlier. The changing hasn't stopped. It's done by people you'll never meet, and you'll be held to whatever they land on. Go find out what your state changed and when. Then sign what you can actually read.